I'm Ryan Baldwin with Senior Resources and Benefits, and I have Craig Riffle here today with me. He is an attorney, a CPA, and he's been helping his clients for 30 years now with asset protection, estate planning, and long-term care. And today we're going to discuss your most recent article, the Revocable and Irrevocable Trusts. Which ones count?
Yeah, the reason I wrote the article is because there's a lot of confusion over which assets and which trusts, which do they count.
Yeah.
Revocable trusts are ones that are created by an individual in which there's an ability by the individual to revoke or amend or whatever it may be. An irrevocable trust is created by an individual and they do not have the unilateral ability just to, under the trust document, just to revoke or amend or whatever it is.
Sure.
Over the years, though, Ryan, what we found is that attorneys, the general public, caseworkers, they oversimplify that analysis. I mean, they think that if the assets are held in a revocable trust, assets in a revocable trust are countable for Medicaid purposes, while assets held in an irrevocable trust are not. And that is, like I said, an oversimplification. If someone follows that dichotomy, they could run into several different pitfalls.
Yeah, that makes sense. Okay, so let's just start at the base. What's a trust?
Well, a trust is a document which you have three parties to a trust. You have the settlor, sometimes referred to as the grantor. That's the person that creates it.
Okay.
And what they're doing is they're creating it's a document, basically a contract, if you will, a trust document, in which they're taking legal title to assets and they're putting it, placing it in this title of this named trust.
Okay.
And so this trust has a trustee, and the trustee is the one that is in charge of managing the trust, managing the assets, those type of things, for the benefit of the third party, and that's the beneficiary or beneficiaries.
Okay.
And there can be more than one, whatever it is, and there can be more than one trustee. So those are really your three parties. But what happens is legal title is separated and put into this trust, which is managed by the trustee for the benefit of the beneficiaries.
Okay, and so the trustee is kind of the person in charge of it, and then the beneficiary is the person that's going to receive any of the benefits and all that type of stuff.
Correct.
Okay, gotcha. Now, you talk about irrevocable and revocable. Give us a little bit more detail on that, if you would.
Well, the problem that you run into, the revocable means that it's typically the person, the settlor, the grantor, has the right to change or amend it at any time, where an irrevocable trust doesn't vest that right with anybody. They don't have the right to do that, so it can't be changed or amended at any time.
Okay.
The real problem that's come in this context, the reason I wrote the article, is because there's two concepts that when you read the rules, the regulations, and it's a mixture of different federal and state rules and Social Security rules and stuff like that. But there's a basic overall rule that an asset, everything people own are assets, but not all assets are countable resources. See, assets are not counted for purposes just because they're an asset. They have to meet the definition of a countable resource, which means that the individual must own or have the power to control the assets or receive the asset and liquidate it to use for their care within a 20-day time period. And so many times, that's one concept that's out there that all trusts and all assets have to fall within. The other one is one that deals with there's a rule dealing with trust, which says that a revocable trust is typically considered to be, the assets of that is typically considered to be countable resources, while the assets of irrevocable trust are not considered to be countable resources, but only to the extent they can be used. Well, the two problems here is, first of all, when you're dealing with trust, they have to fall within that definition. It's got to be accessible, they can use it and stuff like that.
Yeah.
But what the rule with trust does is it presumes that the person creating the trust is the applicant. Now think about that just a minute. If the applicant is the one creating the trust and being the settlor, right? And the settlor is the one that typically holds the power to revoke it, then that would be true. The assets in that revocable trust, if it's the applicant that has the power to revoke it, they would be countable resources, right?
Yeah.
Because under the general definition, they can go in, they can access the asset, they can liquidate and use to pay for care. Where if they're the settlor of an irrevocable trust, it cannot be a countable resource because they don't have the ability to do that. But the problem with just applying that rule and not taking it in the overall context of the accountability of resources is because that rule presumes that the person creating the trust is the applicant. In many cases, it may not be.
Right. It could be the family members or
Yeah, let me give you an example. One of the examples we talked about in the article. Let's say we have a revocable trust that's created by another person for the benefit of the applicant.
Okay.
And the other person, whoever that may be, whether it's a child, whether it's a other family member, third party, whatever it is, that other person holds the ability to revoke that trust, not the applicant.
Okay.
Let's say the applicant is a beneficiary of the trust and has a right to, and then you get into income, principal, and stuff like that, which is beyond the article. But let's say that the third party has that right and not the person. When you look at the trust rule, it says you would count the asset, but that presumes that the applicant is the one that holds that power. They do not. So if you go back to the regular basic rule and says, okay, well, the applicant, to count it against them, the applicant has to be the one that holds that power. Well, they don't under the trust document. And so the problem with saying revocable trust count, it's based upon the assumption that the trust is revocable by the applicant. In your scenario where you said that someone else created it's revocable by them, that applicant doesn't have any control of the asset.
Right.
Therefore, it's not a countable resource under the definition.
Gotcha. That's really interesting. I've heard a lot that, well, I already have a trust, so I'm not going to qualify for Medicaid. But through this article, I learned that's definitely not the case.
Well, you're right. Some people will come in, and I hear the reverse too. They'll come in and they'll say, well, I've got a trust, I'm okay. Or then sometimes you hear, I got a trust, I won't qualify. The actual rule is you, again, kind of like the article spells out, is you can't just put a blanket yes or no on that answer. It depends upon the terms of the trust. It depends upon a variety of different factors beyond revocability or irrevocability. But also, when you look at those two concepts, whether it's revocable or not, it depends upon who holds that power and that type of thing. It also has to be considered. On the flip side, on the irrevocable trust, some people think, okay, I set up an irrevocable trust, doesn't count. In fact, some people will make that conclusion. What's unique about an irrevocable trust, and we're starting to see regulations developing as we speak, that they recognize the fact that there are powers under state law where an irrevocable trust can be revoked. And that surprises a lot of people.
Yeah.
I mean, people will come in and they'll have an irrevocable trust and we'll talk about revoking it or amending it. And some people think that I've got an irrevocable trust, it's set in stone.
Right.
It's etched in stone, can't be changed. And what I'm talking about is every state has a set of statutes that allow for an irrevocable trust to be revoked. Oklahoma's, many of them are like Oklahoma's, but Oklahoma's in particular talk about the fact that if all parties to the trust agree to revoke it, then the trust can be revoked. So take a scenario where, let's say, remember we talked about the three parties, and when it really talks about those parties, it really talks in terms on the revocability of the irrevocable trust, talks about the settlor and the beneficiary. So let's say we have an irrevocable trust that's created by the Medicaid applicant, but it's irrevocable. So most people think, okay, it doesn't count. But the applicant is also the sole beneficiary. What those new regulations recognize that under state law, that individual being both the creator of the trust and the sole beneficiary, although the trust is irrevocable, has the power under state law to revoke it. And so therefore they can take the assets back.
Yeah.
So under that dichotomy of revocability and irrevocability, most people would think it's irrevocable, it doesn't count, when in reality it will, because they hold the ability. So it all goes back to that definition of do they own, or do they have the ability to access the asset? You have to look at the trust, regardless what you call it, regardless how it's structured, you have to go back and look at the fact, does the Medicaid applicant hold that power? And you have to analyze it that way. And any kind of shortcut into, just classifying revocable trust or irrevocable trust as being countable or not can lead to some unexpected consequences.
Yeah.
So when you get into people that come in and say, well, I've got a trust, it doesn't count or it does count, we're asked to review trusts all the time, and so we have to get the trust document, we have to go through it, we have to know the parties, who set it up, is there a revocability power, do they have the ability to revoke it or not. The other thing too that the article doesn't really talk a lot about that goes beyond revocability is what rights do they have into those assets? What I mean by, can the trust make principal distributions? How can those be made? So it's not anybody that gives an opinion and says, well, if you got this type of trust or that type of trust, it's countable or not, is really doing both themselves and the people are talking to an injustice.
Yeah.
Because there's no way to know unless you actually look at the document and apply those rules.
Get into the details of the contract.
Because it all, like I said, the rule that even, if you go to the statutes and you read about, in Medicaid, you read about revocable trust and irrevocable trust, about how they're treated, what you've got to realize is that statute is based upon the presumption that the applicant is the one that created the trust. And like in your example you gave earlier, if the applicant wasn't the one that created the trust, then that rule isn't going to work that way. It all goes back to their ability under the general accountability definition whether they can access those assets.
Wow. What about, how often should I get the trust updated, or does that matter, or how does that work?
Some attorneys will tell people to do an annual review on their trust. I follow a little different rule. I think you have to pay attention to your estate plan and visit it after every life-changing event.
Okay.
So in other words, you can, and people ask, well, what's a life-changing event? Well, maybe marriage, birth of a child or grandchild, death of a child or grandchild, divorce, those type of things. What the attorney should do, and what we do in our office, is every client that we have that has any type of trust, when a case comes in, it's coded at a particular type of case. So if there's any kind of law change or something like that, we send out notices to say, hey, you need to be aware that this will affect your trust. But attorneys are not, and the planners are not aware of life-changing events. And so what I tell people, after every life-changing event, you could have multiple of those in 1 year, which would require a review of the trust more frequently than annually, or you may be able to go a number of years without that. In any event, I suggest most people pull it out and at least pay attention, dust it off, even if they haven't had any life-changing events, about once every 3 years or so.
Okay. And
just make sure everything's in order and things like that, and ask those questions, what needs to be done. You make a very good point. I mean, a trust is a breathing, living document. And it's designed to be used. It's not designed to be something that's just done and stuck on a shelf and forgotten.
Check, that part's done, and now we don't have to worry about it.
Yeah.
So
there isn't a lot of maintenance. People will, and I don't want to scare people about trust. People ask the question related to that, well, what kind of maintenance involved in the trust? And there's very little. I mean, in most trusts, the income gets reported on their tax return, so it doesn't even have a separate tax ID number.
Okay.
There's no filing that they have to do. In fact, right before I walked into this interview, I had a client that had called and say, okay, I need to make sure my trust is still registered. Well, you don't register trust with the Secretary of State or anything like that.
Right.
So there's no registration or anything like that. You have to keep up to date. There's no annual fee that you pay for the trust, or like you do
kind of like an LLC and all that type of stuff.
Yeah, it just doesn't work that way. It's pretty much it's a good instrument that doesn't require a lot of maintenance. But the biggest concern, the reason I wrote the article, is because we've run into this idea that people are classifying assets, whether they're countable or not, based upon what type of trust they're in.
That's not really the case.
No, in the article I give 2 examples, and I just gave you 2 where, based upon their analysis, they would be completely wrong, whether it's a revocable or irrevocable trust.
Yeah. Well, thank you so much. I know the term of how long or how often you should check your trust wasn't in the article, so thank you for giving that additional information.
No problem.
We are out of time. I sure appreciate you coming in today and talking to us about this, and we'll talk again.
Thank you for the time.